Another well accepted norm is that the revisional jurisdiction of the higher court is a very limited one and cannot be exercised in a routine manner. One of the inbuilt restrictions is that it should not be against an interim or interlocutory order. The court has to keep in mind that the exercise of revision jurisdiction itself should not lead to injustice ex facie, where the court is dealing with the question as to whether the charge has been framed properly and in accordance with law in a given case. It may be reluctant to interfere in exercise of its revisional jurisdiction unless the case substantially falls within the categories aforestated. Even framing of charge is a much advanced stage in the proceedings under the CRPC. Next para. This court in the aforesaid judgment has also laid down principles to be considered for exercise of jurisdiction under section 397, particularly in the context of prayer for quashing of charge framed under section 228 CRPC is sought for as under. Next para. Having discussed the scope of jurisdiction under these two provisions, that is section 397 and section 482 of the code, and the fine line of jurisdictional distinction, now it will be appropriate for us to enlist the principles with reference to which the courts should exercise such jurisdiction. However, it is not only difficult but is inherently impossible to state with precision such principles. At best, and upon objective analysis of various judgment of this court, we are able to cull out some of the principles to be considered for proper exercise of jurisdiction, particularly with regard to squashing of charge either in exercise of jurisdiction under section 397 or section 482 of the code, or together as the case may be. Next para. 1. Though there are no limits of the powers of the court under section 482 of the code, but the more the power, the more due care and caution is to be exercised in invoking these powers. The power of quashing criminal proceedings, particularly the charge framed in terms of section 228 of the code, should be exercised very sparingly and with circumspection, and that too in the rarest of rare cases. Next para. The court should apply the test as to whether the uncontroverted allegations as made from the record of the case and the documents submitted therewith prima facie establish the offence or not. If the allegations are so patently absurd and inherently improbable that no prudent person can ever reach such a conclusion, and where the basic ingredients of a criminal offence are not satisfied, then the court may interfere. Next para, the High Court should not unduly interfere. No meticulous examination of the evidence is needed for considering whether the case would end in conviction or not at the stage of framing of charge or quashing of charge. Next para, another very significant caution that the courts have to observe is that it cannot examine the facts, evidence and materials on record to determine whether there is sufficient material on the basis of which the case would end in a conviction. The court is concerned primarily with the allegations taken as a whole, whether they will constitute an offense, and if so, is it an abuse of the process of court leading to injustice? Next para, quashing of a charge is an exception to the rule of continuous prosecution, where the offense is evenly broadly satisfied. The court should be more inclined to permit continuation of prosecution rather than its squashing at that initial stage. The court is not expected to marshal the records with a view to decide admissibility and reliability of the documents or records, but is an opinion formed prima facie. Next para, the revisional court cannot sit as an appellate court and start appreciating the evidence by finding out inconsistency in the statement of witnesses, and it is not legally permissible. The High Courts ought to be cognizant of the fact that trial court was dealing with an application for discharge. Next para, in the teeth of the above analysis of law, when the impugned order of the High Court is perused, it would not detain us for too long to brush aside the contentions raised by the respondent accused for reasons more than one. Firstly, the charge sheet has been filed after taking into consideration the written submissions filed by the accused before the investigating authority, which included the documentary evidences tendered by the respondent accused. Secondly, the statement of friends and acquaintances from whom loans of large amounts had been borrowed by the accused, which had been relied upon by the accused to stave off the prosecution in his written submissions filed before the investigating authority, and which material had persuaded the High Court to accept the same on its evaluation to be true, is nothing but short of accepting the same as defense evidence and examining the truthfulness of its contents even before trial could be commenced or held. Thirdly, the High Court has proceeded to examine the pros and cons of defense by weighing the defense evidence and probabilities of the conclusion that may ultimately be arrived at as the basis for exercising the revisional jurisdiction, which was impermissible. Fourthly, the purported loans said to have been obtained by the respondent accused from his mother, brother, and father are all question of facts, which requires adjudication, and this could be done only during trial, and the explanation relating to borrowing of large sums raises a reasonable suspicion, which has been termed by the investigating agency as strong material to file the charge sheet, and based on such material, the sanctioning authority also recorded its satisfaction under section order dated 5/3/2015 to prosecute the respondent accused. Hence, raising reasonable suspicion cannot be held or construed at the primary stage for discharging the accused.